Many real estate investors think that once they set up an LLC, they're immune from personal liability. And that's simply not true. The thing is that it's not just about setting up your LLC correctly. Yes, that's important. But what's even more important is how you operate your business once you set up your LLC. And there's one extremely common mistake that many real estate investors make when it comes to their LLCs. This one mistake completely undermines the whole purpose for getting an LLC and immediately opens you up to unlimited liability. In this video, I'll explain what the mistake is and how you can avoid it. Coming up. Hey guys, if we're just meeting, my name is Vitaly Volpov. I'm a real estate investor, attorney, and a part owner of a real estate brokerage in upstate New York. I currently own over 100 rental units, and my goal is to help 1,000 other like-minded people reach financial independence through real estate investing. Please like, follow, and subscribe if you find this video helpful. Since I'm going to be touching on some legal concepts, keep in mind that what I'm offering is not legal advice. This video is for educational and entertainment purposes only, and you should always consult with your own attorney before making any legal or financial decisions. All right, so let me ask you this. Have you ever heard of the concept called piercing the corporate veil? No? Okay, we'll get back to that one in a minute because it is critical to this whole discussion. First, let's just make sure we're on the same page about what exactly an LLC is supposed to do and what it's not supposed to do. An LLC is not your get out of jail free card. It's not a magical shield that can block any lawsuit that comes your way. And you can't just do whatever you want in your business just because you have an LLC. What it's designed to do is to create separation between your business and your personal activities and assets. In other words, when you use an LLC to run your business activities, it's as though you've created a robot clone of yourself, which works solely on your business. It doesn't get involved in anything else outside of your business. It doesn't buy your groceries, it doesn't clean your pool, and it doesn't mow your lawn. All it does is it runs your business. And if you have other businesses which are operating under other LLCs, it doesn't have anything to do with those either. The reason you want this separation to exist is very simple. It's so that if there's ever a liability incurred by your business, the only recourse a plaintiff will have is against that business and its assets, nothing else. So it doesn't mean that after you get an LLC, you can't be sued for something you did while running your business. And it doesn't mean that you can't lose that lawsuit. You can be sued and you can lose. But it does mean that if you lose, the plaintiff won't be able to take any of your personal assets or assets that belong to any of your other businesses. So how can you go wrong when you run your real estate business through an LLC? Well, you can go wrong by disrespecting the legal separation that's supposed to exist between yourself and your company. And this is where the concept of piercing the corporate veil comes in. Piercing the veil is essentially a legal theory which states that because the individual, through his various actions, didn't respect the separation between himself and his LLC, the court adjudicating a lawsuit against the LLC and the individual should not respect it either. The legal theory goes that where a court determines that the lines between the LLC and the individual were blurred to such an extent or disrespected so significantly, both are treated as one and the same, and the assets of both can be used to satisfy a judgment that results from a lawsuit. So what exactly does disrespecting the legal separation between you and your LLC mean? Well, let me give you some examples to help explain it better. Let's say you own a property in the name of your LLC. Everything is going fine, the property is rented, and the rents are covering most of the property's typical expenses. But after some time, you find out that you need to replace a roof, and the roof replacement is going to cost $15,000. Let's say that there's not enough money in your LLC bank account to cover that cost. So you get your checkbook and write a $15,000 check from your personal bank account directly to the roofer that does the work. Sometime later, let's also say you need to repair a furnace for which the LLC also doesn't have enough funds. In order to pay the HVAC company, you throw it on your personal Visa card. Things go fine after that, and you don't incur any additional major expenses. And after several months, you accumulate a decent amount of money in the LLC bank account from the rents that continue to come in. You then decide to spend some of your profits and you pay for a bunch of personal expenses on your LLC's debit card. Maybe you pay for your kid's basketball camp, maybe you buy yourself a nice watch, and you pay for your family's vacation, all on your LLC's debit card. Do you see anything wrong with this example? Everything I just described tends to show a pattern of disregard for the legal separation that is supposed to exist between you and your LLC. I hope you can see why that is, as it should be pretty obvious even to a non-lawyer. There are also other examples I can give you. Let's say you never even opened a bank account in your LLC's name. Instead, you used your personal account for everything. You'd have rent going into that account, wages from your job, a birthday gift from your Aunt Ruth, that big win you got at the casino, and so on. You also pay all of your property's expenses out of this account, as well as your personal expenses. Do you think that you're respecting the legal separation if you manage your finances this way? Do you think that there's a risk that your LLC will be pierced under these circumstances? Let me give you one more example that may be a little bit more controversial because the practice is so common. Let's say you buy a rental property in your personal name and get a mortgage with a bank in your personal name to finance the purchase. Shortly after you close, you go and create an LLC and you transfer the title of the property from your personal name into your LLC. But you don't refinance or restructure the mortgage from your personal name into your LLC name. You also never change your property insurance from your personal name into the name of your LLC. What I just described is a very common practice among novice real estate investors, and it can be used against you by a savvy plaintiff's lawyer to argue that you're not respecting the legal separation between yourself and your LLC. The plaintiff's lawyer would say that the individual and the LLC who engage in this type of transaction are one and the same because they are treating the assets and liabilities of one another interchangeably. And he really wouldn't be wrong here. There's no business or financial reason for the individual to transfer the title of the property to the LLC while continuing to remain liable on the mortgage under the circumstances described. If this LLC were owned by some unrelated party, it would obviously be crazy to make a transfer like this. The only reason this was done this way in our example was because the LLC is owned and controlled by the same person. Whether this argument is successful or not in court will depend on the judge and the facts involved in the particular situation. But it certainly doesn't help your case when you're trying to say that your LLC should be solely responsible for any liabilities stemming from your rental property. Okay, so now that you've heard about what not to do, what are the types of things that you should do to help ensure that your LLC will actually serve the purpose of limiting your liability? Well, first of all, you absolutely must maintain separate finances for you and your LLC. This means that you need to have a separate bank account for your LLC. It also means that all the income earned by the LLC has to go into that account and never into your personal account. It also means that all of the expenses must be paid from the LLC's account and not from your personal account. But what happens if there's not enough money in your LLC account to cover the expenses? Well, you can either make a member contribution to the LLC account from your personal funds, or you can loan your personal funds to your LLC. Regardless of which method of funding your LLC account you choose, you need to make sure that you properly document what the money you put in represents. If you're making a contribution and depositing funds electronically, you should have your bank put a comment on the transaction indicating that it was your member contribution. If your bank doesn't have that capability, consider depositing funds using a check and write the purpose of the deposit in the memo section of the check. An image of the check with that notation will serve as evidence of what the deposit was for. If it's going to be a loan, you should draft and sign a loan agreement between yourself and your LLC, specifically identifying the terms of your loan and signing the loan agreement in two places, once on your own behalf and separately on behalf of your LLC. It also wouldn't be a bad idea to create another document such as a member resolution indicating that the members of the LLC, in other words you, believe that it is in the best interest of the LLC to borrow the funds from you to cover the shortfall. Once you fund the loan, you also have to make sure and remember to charge your LLC a reasonable amount of interest and to make regular payments as outlined in your loan agreement. Once you've made the member contribution or the loan and your LLC has sufficient funds to cover the expenses, you would go ahead and pay for those expenses out of your LLC account. Similarly, when it comes time to take profits from your LLC, you should make sure that you take those profits in the form of a member distribution. This means that you would either write a check or do an electronic funds transfer from your LLC account into your personal account. And you should make sure that you document this distribution the same way you would document a contribution. Never ever use your LLC funds to make personal purchases. Transfer the funds from your LLC account to your personal account as a proper distribution first, then do whatever you like with that money. Aside from finances, you should also make sure that you're never commingling any of your and your LLC's obligations. So if you're going to transfer your property into your LLC, the best practice is to refinance any mortgage that you have in your personal name into the name of the LLC at the time you make the transfer. The same thing goes for your property insurance and any other financial obligations associated with the property. Any obligations should now be the legal responsibility of the LLC and nothing should be in your personal name. You should also comply with any special rules for LLCs that may exist in your state or local jurisdiction. If there are certain forms you're required to file, you should file them. And if there are special taxes or fees that you have to pay, you should make sure you pay them on time. The general idea here is that you want to do everything you can to limit the ability of any plaintiff to say that you didn't respect the legal separation between you and your company. Of course, please consult with an attorney who knows the laws and regulations of your jurisdiction to find out exactly what you're required to do and file with regard to your LLC. With that said, that's going to do it for this video. If you guys found it helpful, please leave a like. And if you haven't yet subscribed to my channel, definitely subscribe so you don't miss any of my future videos. Thanks again for watching. Have a great day, and I will see you in the next one. Take care.